see that in the context of women. It says, for the purposes of the present convention, the term discrimination against women shall mean, now please note, any distinction, exclusion, or restriction made on the basis of sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on the basis of equality of men and women, of human rights and fundamental freedoms in their political, economic, social, cultural, civil, or any other field. So once your lordship says that is the right to marry, then your lordship have to see whether these restrictions to a particular group denies that freedom. And the answer is clearly yes. So that is an alternative way of looking at it. And your lordship has used, my lord, the Chief Justice in Miss X versus Principal Secretary. That's the, my lord, and the only thing I want to say is that please read Obergefell again, my lord. I know there's a, my lord,
Please read what again?
Obergefell.
Okay.
Now, my lord, I want to just say that I agree with Mr. Singhvi. I don't agree with Mr. Rothgi's solution of affidavit. What I would suggest is what your lordships are looking at as a Y media. The special marriage can be a conduit until Parliament enacts, as in Vishaka. Until Parliament enacts, with all its limitations and faults. Now, my lord, I want to read a short poem in the context of what I said. Please appreciate this, my lord. Because it's sexuality which is abhorrent to people. And that thing has to be overcome, that psyche. And my lord, this is a very famous poem by James Kirkup, which led to an obscenity case, and there's a judgment of the Court of Appeal. White House versus Lemon. This is the passionate and blissful crucifixion of same-sex lovers suffer patiently and gladly. They inflict these loving injuries of joy and grace, one upon another, till they die of lust and pain within the horny paradise of another's limbs, with one voice cry to heaven in the last divine release. Then lie long together, peacefully entwined, with hope of resurrection, as we did on that green hill far away. But before we rose again, they came and took him from me. They knew what we had done, but felt no shame or anger. Rather, they were glad for us and blessed us, as would he who loved all men. And after 3 long, lonely days, like years, in which I roamed the gardens of my grief, seeking for him, my one friend, who had gone from me, he rose from sleep at dawn and showed himself to me before all others, and took me to him with love that now forever dares to speak its name. Lord, is poignant. I think we should all recognize that our sexualities are no different. Thank you.
Thank you, Mr. Grover. Yes, Ms. Kothari.
Yes. My lords, the argument was made that any kind of My lords, an argument was made that any kind of reading in into the SMA would go against the core or the grain of the legislation using the Gaidan phraseology, and therefore reading in persons cannot be permitted. My lords, I want to submit that the core of the SMA from the parliamentary debates is that it moved away from the sacramental nature of marriage to a contractual nature, and its core was freedom of choice in marriage. And my lords, the parliamentary debates, my lords, may just kindly see my submissions, rejoinder submissions, my lords. Parliamentary debates we have now obtained and they are extracted, which clearly show that the core of the SMA was free choice in marriage and it did not exclude any person. Even in 1954, of course, at that time it was a man, woman, but this was irrespective of faith and caste and based on constitutional principles. My lords, may just see page 2 of my written rejoinder submissions. In page 2, I will just read
Yes,
out
we've made the point. What,
yes,
yeah,
one or two extracts where one of the
we see the point. What is the next point, Ms.
My lord, I will just read out one extract on page 5, that where one of the members in the debate says that we are living under a constitution where certain principles are guaranteed to individuals, liberty of speech, liberty of association, which in my opinion includes the right of every person to choose his or her partner as she desires.
All right. What is the next point, therefore? Yes.
So my
The sequitur.
Yeah, my lords, is that the debates show that even the SMA was a marriage law for freedom of marriage and choice, and therefore, my lords, reading in as persons would in fact not go against it and would be required for a constitutional framework. And it was never meant to exclude anyone, my lords. And my lords, therefore, reading in, while other judgments have been relied upon, I go on to independent thought. My lords, in independent thought, the exception to rape, 375, in fact, an argument was made that would it be reading up and would the exception to rape for the marriage of a woman, wife aged 15 to extend it to 18, would it be seen as making a new offense? That's what the court asked. Can we make a new offense? And then the court said that we are not making a new offense, but if we don't read 15 as 18, we are in fact failing our constitution duty. And in fact, the court said what Justice Lokur and Justice Deepak Gupta said, that the court said that if we want to make a purposive interpretation, they did not term it reading in or reading up or reading down, but to give a purposive interpretation that protects the rights of the girl or minor girls under the constitution, because the age of marriage was 18, she would lose her right to choice in education and in life. There we have to step in. And in fact, the court said that the court would be failing in its duty if the legislature enacts a law which is violative of the fundamental rights of citizens, is arbitrary and discriminatory. The court would be failing in its duty if it does not either strike down the law or read the law in such a manner that it falls within the four corners of the Constitution. That's all we are asking, my lords, to read it in a way that persons are included, to cover it and make it constitutionally compliant. And my lords, finally, the last point is that, my lords, for trans persons, NALSA specifically guarantees the right to marry. There is a specific requirement that legal recognition is required for enjoying all civil rights by this community, the right to own property, the right to marry. When there is a right to marry, and my lords, when under the Special Marriage Act, transgender persons who have got their gender reassignment can come within man or woman. My lords, all we are saying is that give an interpretation that is purposive to make it all persons, my lords.
Thank you so much, Ms. Guruswamy. Thank you so much, Ms. Kothari. Ms. Guruswamy?
May it please, my lords. My lords,
Yes, Dr. Guruswamy.
My lords, this is my rejoinder submissions, very short, my lords. Serial number 21 in the rejoinder submissions. I've tried to keep it quite brief. I'm responding specifically to the submissions on same-sex parenting, my lords, and adoption rights of same-sex couples by the argued yesterday by the National Commission for the Protection of Child Rights. I don't do so on my personal opinion. I do so on behalf of the Delhi Commission for the Protection of Child Rights. I have also attached, unlike the state, multiple studies with strong methodology, as well as other constitutional court decisions, South Africa, Brazil, multiple other constitutional courts on the right of same-sex couples to adopt, to parent, to be treated as a family, and to be given an equal dignity, and not be reduced to the category of those people. My lords, if I may, my lords, this is serial number 21. Right, please, my lords. Now, my lords, page 2 of my written submissions is a statement of the Indian Psychiatric Society that consists of 7,000 psychiatrists all over this country. My lady Justice Kohli has the submissions, my lady.
Looking, I don't see,
This is serial number 21, my lady.
not there, a few minutes before. You've just mailed it.
Oh, this is a new one.
You knew one.
This is just rejoinder submission, my lord.
But
Just
you already have, you already gave one last night, didn't see it?
it's the same rejoinder submission. It's
We'll share it. I have it. with
very well.
Mailed it in the meantime, it's being
My
down.
lord Justice,
I've been compelled to learn all this.
There is one which is
working
volume
well for us.
15. There's a volume 15.
Oh,
no,
Rejoinder.
no, my lord, it's
It's a
Okay.
rejoinder submission.
yesterday a folder of all rejoinder submissions. Earlier
But then
yesterday.
you are,
just now,
Oh, I see.
just now,
so the dump continues.
yeah.
Reading and giving purpose of interpretation to legislation. Yes.
Yes,
So-
got it.
Yeah.
So my lord Justice Narasimha has it, my lord. Yes.
Yes, please go on.
Yes. So, my lords, page 2, the Indian Psychiatric Society, which consists of 7,000 psychiatrists or specialists. It's the largest society of mental health professionals in India. The society supported the decriminalization of homosexuality in 2018, and this is what they had to say in April 2023. LGBTQ individuals be treated like all citizens of the country.
It's not here. Wait. Mail it. Oh, abhi kara.
Yes, para 2, my Lord Justice, but that LGBTQ citizens be treated like all citizens of the country, and once a citizen can enjoy all civil rights like education, employment, housing, income, government, military service, access to healthcare, property rights, marriage, adoption, survivorship benefits, to name a few. There is no evidence to indicate that individuals on the LGBTQA spectrum cannot partake any of the above. On the contrary, discrimination which prevents the above leads to mental health issues. And in their recommendation, it is also of utmost importance that the family, community, school, and society in general are sensitized to protect and promote the development of such a child and prevent stigma and discrimination at any cost. This is a child being raised by same-sex parents. Now, my lords, if I may, my lords, there were 4 principal thrusts. So I'm just going to very quickly, I'm acutely aware of the time, my lords. Very quickly, psychological impact of children being brought up in same-sex households, my lords. Now, there are over 50 countries in the world that allow same-sex couples to adopt. So that is more than the number of countries that allow same-sex marriage. Those lists of countries are in the compilation. I'm not going to belabor this here. The most important points is that the big meta studies that have been done over the last 20 years in countries that have allowed same-sex couples to adopt, to have children, the big meta studies by the American Psychological Association, by meta studies in the Netherlands, in Brazil, in South Africa, and all of that is in the note, all make 3 points. One, that there is no adverse impact on same-sex couples having children and those children. 2, if anything, the lack of protection adversely impacts those children. And 3, that human sexuality develops quite early. So if you do not ensure equality and a protection from discrimination, then young people who are LGBTQ will be, in fact, psychologically impacted. This is what all the studies indicate. They are cited from in the note, and I want to take my lords to page 5, if I may. The American Sociological Review, based on very concrete data, has come to these conclusions. The academic results, this is page 5, my lords, of children raised by same-sex parents from birth outperform children with heterosexual parents by 0.139 standard deviations on academic tests. Children raised by same-sex parents from birth are 4.8 percentage points more likely to graduate from high school than children with different sex parents. Support for this hypothesis that has given time-consuming and costly procedures for same-sex couples to obtain children, same-sex parents typically will likely have higher socioeconomic status and therefore better academic outcomes. So I don't want to premise this. I don't want to premise this, and I would hope that in future, when the state comes to argue for or against a case, that the state will locate its findings, its opinions, and form those opinions after talking to communities, after actually relying on studies that do exist for the last 3 decades now in the public domain. Finally, my lords, I want to just take my lords briefly to judgments by other constitutional courts in support of equal parenting rights for same-sex couples. This is page 6 of my written note, my lords. The first case, page 7, para 16. The National Coalition for Gay and Lesbian Equality versus the Minister of Home Affairs. 2000, the year is Constitutional Court of South Africa. My lords, I just want to read these paras because it sums up this conversation here between these two sides that happened 13 years ago in South Africa. It said the South African Constitutional Court says this: from a legal and constitutional point of view, procreative potential is not a defining characteristic of conjugal relationships. Such a view would be deeply demeaning to couples, whether married or not, who for whatever reason are incapable of procreating when they commence such a relationship or become so at any time. It is demeaning to adoptive parents to suggest that their family is any less a family and any less entitled to respect and concern than a family with procreated children. I would even hold it to be demeaning of a couple who voluntarily decide not to have children or sexual relations with one another, this being a decision entirely within their protected sphere of freedom and privacy. In second place, there is no rational connection between the exclusion of same-sex life partners from the benefits of their laws and the governmental interests sought to be achieved thereby, namely the protection of families and the family life of heterosexual spouses. No conceivable way, nor can I think of any.
Dr. Guruswamy,
Yes.
could we have a look at the judgments later?
Yes,
Because
my lord. So
we
these
have 15
judgments.
minutes left, so we'll hear the two others.
Very well, my lords. These judgments are all there. There are multiple constitutional courts, and the DCPCR has given a list, my lords, it's a wish list, but of just guidelines on sensitization and education of society and steps that the government can take. I'm deeply obliged.
Thank you, Dr. Guruswamy. Thank you. Now, who will, Mr. Kripal, you'll be arguing.
Acutely aware that I'm on a conveyor belt. And one thing a conveyor belt does when it is go around. So it just reminds me as to why we started with this case in the first place. The idea, Millets, was to try to be equal citizens in this country, to get the same rights that everyone else has as heterosexuals, homosexuals. And Millets, marriage is a vehicle to adopt and obtain that ideal. It is not merely marriage as a social institution that we want. The reason we want marriage is because it is a conglomeration of rights, as was said on the very first date, that the state gives to you. Now, either we can fight for each of those rights individually, or we can get them in one fell swoop by virtue of a declaration by an act. Now, I quite see the problem with the latter, that if we ask for everything, we might end up getting nothing. So the correct thing for us is to ask for a declaration, as my lords have said, in terms of constitutional sense, that you have a fundamental right to marry. Now, Millets, the moment there is a fundamental right to marry, it follows that any two people have a fundamental right to marry, subject to certain state interests being complied with, which include both heterosexual and a non-heterosexual couple. Thus far, no problem. This declaration can come. But when a declaration must have a certain consequence in as much as it must ameliorate or identify or meet with the problems with which we came to the court in the first place. Because the declaration in a vacuum, saying that the Supreme Court hereby declares that any two people have a right to get married, must in some way be formalized into the practical impact of any two people's day-to-day life. So that when two people say that, look, the Supreme Court has said, I have a right to get married to my partner and therefore give him a visa or open a bank account or get an insurance document, there must be some formal aspect or carrying out in the nitty-gritty details, howsoever little of that larger constitutional declaration of precept. What I would submit, Millets, is Section 4 of the Special Marriage Act gives just such a precept. My lords will recognize a right under Section 4 of the Special Marriage Act, in which case not much violence is done to the act of to Section 4. The problem arises in terms of unworkability once that declaration has been given to all the other rights. And there, I would say, hold your hands. Because it becomes, SMA will not become unworkable for the heterosexual community. It carries on working, it does. There are aspects of the SMA which may become unworkable. But Millets, I would just remind my lords that slightly unworkable is better than nothing. And nothing is what we have just now. So if we get a declaration under Section 4, Millets, it means a lot to any member of a community to go and tell their parents that, look, I'm getting married. It means a lot to any member of the community to say that the Supreme Court of India has permitted me and I have officially gotten married. It is an official document, Millets, which, in my Lord the Chief Justice's formulation of the 5 concepts of what include marriage, which is the ability to exclude, the right to cohabitation, the right to procreation. It is very important to have societal recognition of that relationship. And two people will not get societal recognition of their relationship by an abstruse declaration of the law for any two people by the Supreme Court. It must be carried into practice in some manner. And Millers, therefore, Section 4, a simpliciter declaration that you fall within Section 4 will suffice. To the extent, and my Lord will see Section 4, my Lord just call us in, there is actually no violence to the language of the Act that we will have to do substantially. Notwithstanding anything contained in any law for the time being in force relating to the solemnization of marriages, a marriage between any two persons, no problem, may be solemnized under this Act if at the time of the marriage, the following conditions are fulfilled, namely, neither party has a spouse living, neither party is incapable of giving valid consent to it in consequence of unsoundness of mind, though capable of giving valid consent, has been suffering from mental disorder, has been subject to recurring. The only problems are C and potentially D. C, that the male has completed the age of 21 years and the female the age of 18 years, and the parties are not within the degrees of prohibited relationships. These are the only two sections that will have to be tweaked. If there's a problem that stems from 21A, that is left to a future wisdom. At best, what will happen? That you will not get certain rights. We are not getting those rights today in any case. So what is the worry? How is it an unworkability argument? This is an argument saying that you cannot get everything, so I will give you nothing. That argument will not suffice. The other alternative, Millers, as can be suggested, is Section 15 and 16. There, Millers, these problems of age as well as degree of prohibited relationships don't come in. My Lord will see Section 15. Because a marriage can be solemnized under the chapter 1 of the SMA, it can also be registered under Chapter 3, registration of marriages celebrated in other forms. Any marriage celebrated, whether before or under the commencement of this Act, other than a marriage solemnized under the SMA 72 or under this Act, may be registered. So we get married anywhere else, it can be registered under this chapter by a marriage officer in the territories to which this Act extends if the following conditions are fulfilled. The ceremony of marriage has been performed between the parties and they have been living together as husband and wife ever since. Just stop here for a moment. A ceremony of marriage has not been defined as to what it is. It could be anything. I could go and, either in Jewish tradition or Parsi tradition, because there are different forms. The Act does not say what is a ceremony of marriage. It can be anything. I can go and tell before a priest of my choice or anyone saying, I hereby take you as my spouse. That would fall within the definition of ceremony of marriage because there is no description here in the Act. My choice of ceremony will not run afoul of the Act. And have been living together as husband and wife. This Millers can be tweaked to the extent of spouse. And the words that living together as husband and wife implies that you are in a cohabiting relationship. That is the implication of this particular subsection. But more importantly, let's see clause B has neither party has at the time of registration more than one spouse living. C, neither party is an idiot or a lunatic. This language really needs to be updated. D, the parties have completed age of 21 years at the time of registration. So there, this problem of 18 and 21 does not apply because both parties have to be 21. So whoever it may be. E, and again, parties are not within the degrees of prohibited relationship. So this also is gender neutral. it will apply to a man and a woman. There is no problem whatsoever in a section 15 argument, provided that in the case of marriage celebrated before the commencement, condition shall be subject to any law, custom, or usage having the force of law governing each of them, which permits a marriage between the two. Since it doesn't, this will not apply to us because we are getting married in a ceremony.
Degree of prohibited relationship is unprohibited relationship opposite. Yeah.
The problem (16) is a simpliciter recognition of once you fulfill the conditions in 15, 16 will be registered upon receipt of an application signed by both the parties to the marriage for the registration of the marriage, again gender neutral. Under this chapter, marriage officer shall give public notice thereof in such manner as may be prescribed. And the procedure will follow. So well as this is a gender neutral way of allowing marriage to be recognized. And the third is a submission that Mr. Rodhi gave, which that you allow registration of marriage under section 18F of the Registration Act. Because the only two problems I see with that, the only problem I see with that, and I would commend either section 4 or section 15 route, because both can be followed without much tinkering. Because every other unworkability argument also affects an introduction of Article 31D in our Constitution. Because future parliaments will now become very clever and say, why should I bother with amending the Constitution to save a legislation? I will just make it so complicated that striking it down becomes unworkable, and it therefore has a constitutional protection. For instance, whether the reservation is to be given, I will give 2% reservations to 30 scheduled castes and not to the 31st. And say, well, if you struck it down, there's no reservation for anyone. Out it goes. Well, this is just one example of a potentially unworkable act being struck down, being rendered immune from judicial review on the ground of unworkability. There is reason why no case has been cited before my lords where the word unworkability has been used as a defense to constitutional examination, because it is not a valid constitutional defense. It is a purely legislative act which they're seeking now somehow to get over our fundamental rights by legislative device. That's something that cannot be permitted. That's all I have to say.
Thank you, Mr.
And let's just, we have an affidavit of Mr. Rodhi wanted to circulate as to what kind of affidavit can be given in case the registration under section 18F of the Registration Act is to be done. It's in volume 24 of our submissions. Obliged, my lord.
Yes, Ms. Grover.
Please, my lord. My lord, since my petitioners fall into two different groups, my prayers also, one relates to Special Marriage Act, which has been extensively argued. I would only add one strand to that for my lord's consideration, which is the ratio of Dharani sugars. That statutes must be treated as always speaking. My lord, the Chief Justice has applied that very ratio in Miss X versus Principal Secretary Health to read the impugned rules under the MTP Act to recognize a single woman's right to abortion where it related specifically to marital status. So whether that ratio can be deployed here to recognize LGBT couples' marriage within Special Marriage Act. My lords, the other prayers in my petition, which relate to those who do not wish to necessarily be married within the legal regime, have not been countered or opposed either in the counter affidavits filed or in the oral submissions, which are three prayers. One, to recognize, give constitutional recognition to my right to form a chosen family, which has already found recognition in the atypical family that my lords have elucidated upon. Then, which are can also be non-conjugal in intimacies that persons may have who are queer and trans persons. The second is the right to nominate beyond guardian, blood relative, or family member and assign various rights. And again, a constitutional recognition to that. And the third, which Mr. Ramachandran has already mentioned, a protocol of protection from violence, both building upon Shakti Vahini and the Madras High Court order, but ensuring that that provides agency and autonomy to those who are being safeguarded and protected. My lords, just one last bit in terms of non-workability. Again, I think Mr. Ramachandran has mentioned, because there was a lot of concern expressed by the respondents, the experience of NALSA and the Transgender Act. different high courts, whether on issues of domestic violence, sexual violence, reservations, have made it workable, and that is an ongoing process. I would only reiterate what has been said just now again, to say that these are vulnerable, high-risk populations, particularly when there are further marginalizations of class, caste, etc. Non-recognition and non-granting of certain rights will certainly increase the discrimination and violence. So it is an Article 21 issue also. I'm very grateful.
Thank you, Ms. Prabhu.
My lords,
Yes, Nandi.
my lords have my submissions in
Yes.
rejoinder dated 10th May. It's in the
Yes.
common compilation that was sent, I think, yesterday morning, my lords. My lord, there are three propositions. One, happily, has been dealt with by Mr. Kirpal, that Chapter 3 of the Special Marriage Act, Sections 15 to 18, require the registration of marriages celebrated in other forms, and that these are gender neutral and may come to our aid without any words whatsoever being read into the Special Marriage Act, my lords. My lords, Mr. Kirpal has very well taken you through the section, so I won't do that. I will only add that when the section says as husband and wife should have been living together since the celebration, Black's Law Dictionary, the Oxford English Dictionary, it all comes to our aid, and it says that as means like, similar to, of the same kind, in the same manner. My second proposition, my lords, is that to the extent the phrase forms of marriage under Section 15, Chapter 3, presupposes extant validity under law, the common law may be brought to bear to develop the contours of the right through stare decisis. My lords, it would be remiss of me to mention, despite the time, that Professor Tarunab Khaitan and Professor Mitra Sharafi have helped us with these submissions under a lot of pressure of time. The life of the law, my lords, as Oliver Wendell Holmes says, has not been knowledge, it has been experience. So therefore, the fact that we have been here before is relevant. That Parsi marriage laws, and I'm reading from page 3, my lords, that Parsi marriage laws were a creature of common law prior to their codification. There is no religious source. Not that there was never any religious source, but at the time that they were looking at it, there was no religious source. During the emigration from Persia, their books were lost, creating a vacuum in law. And we have cited Dr. Sharafi's book, which has looked into this, and her dissertation was specifically on these issues. Marriage and divorce between Parsis, therefore, was regulated by English ecclesiastical or Christian law. Default for Zoroastrians living in presidency towns. In Kasarchi versus Piroz Boy in the Privy Council, the appellant husband objected to this. He said, look, Christian laws can't apply to me, surely. He said that the jurisdiction of the court to decide the matrimonial dispute between a Parsi couple and to apply Christian law.
In rejoinder, you will have to specifically take up the points which they have argued and then tell us.
My lords, the point is only
Read the
this.
points that they have taken.
Yes, my lords. My lords, the point that they have taken is that they said that we are, essentially they said that we are in a vacuum. That ecclesiastical jurisdiction doesn't apply, but on the civil side, the civil courts can develop it.
Literally. The Parsis' migration predated the advent of the Europeans. So they had regulated within their own institutions, marriage, the solemnization, separation, whatever else. The advent of the British only lent a forum and perhaps a codification.
My lords, I'm so grateful. My lords, what the judgment says and what the commentators at the time were divided on was what they should do when there was no ecclesiastical law. So the solution they came to is that they said that let the Supreme Court of Bombay on its civil side develop it on a case-by-case basis. And so they said, and I've reproduced it all here. I also have the references, my lords. What they said was that we understand that ecclesiastical law should not apply, but we should much regret if there were no court and no law whereby a remedy could be administered to the evils which must be incidental to married life amongst them. We do not pretend to know what may be the duties and obligations attending upon the matrimonial union between the parties, nor what the remedies may exist for the violation of them. But we conceive that there must be some laws or some customs having the effect of laws which apply to the married state of persons of this description. It may be that such laws and customs do not afford what we should deem as between Christians an adequate relief. And so then they go on to say, such remedies we conceive that the Supreme Court on the civil side might administer, or at least remedies at nearly approaching to them as circumstances would allow. Proceedings might be conducted on the civil side with such adaptation to the circumstances of the case as justice might require, though on the ecclesiastical side, such modification would be wholly irreconcilable with their particular situation. My lords, what we are saying is that a declaration would go a long way towards recognizing my rights. But my lords, what I am saying also is our plea is to bring the Constitution to my home as well. Do not let my humanity, my lords, be reduced to a separated singular identity. My lords, allow me to consecrate my love. I'm so grateful, my lords.
Please, my lord. I'll just put 3 points before my lords. The first is that my lords are contemplating whether the Constitution recognizes a fundamental right to marry. That, my lords have indicated, perhaps may be found across the rights that are enumerated in Part 3. And, my lord, that the right to marry would have certain contents which are already recognized under law through various statutes. My submission in this regard would be that it fell from your lordships on the previous date that the contents would include, my lords, for example, the right to found a family, the right to procreation, and so on and so forth. The first content I would submit, my lords, of this right to marry must be the status of being married itself. This is, my lord, distinct from the rights and obligations that flow from a marriage. The status of being married, my lord, the recognition of the relationship itself confers a couple with dignity. This is, my lord, dehors any rights and obligations that flow from the marriage. And therefore, my submission, my lords, that the first right, my lord, that is recognized, the first content of this right to marriage, my lord, would be the recognition of the marriage itself and the status of being married.
Yes.
Please, my lord. That's my first submission. The second submission, my lord, is this, that it was indicated to your lordships yesterday that if my lords were to give such a declaration, it would bind future parliaments. It would bind future courts. And that is the nature, my lords, of Article 141. It is inherent, my lord, to the obligations of this, the constitutional obligations of this court. In Nalsa, my lord, the formulation which, and Nalsa, my lord, as the nodal judgment when it comes to questions of gender identity and sexual orientation, the formulation that this court gave was first to indicate, my lords, the content of Part 3 rights when it came to transgender persons, and then, my lord, to actualize those rights through specific directions that your lordships gave to central and state governments. So, my lords, I'm completely with my friends on this side that any declaration that your lordships give must be actualized through an enunciation of the Special Marriage Act. But in addition, my lords may see the declaration that your lordships have given in Nalsa, and I believe my note may have reached your lordships too late to be uploaded, so I won't trouble your lordships with it. But, my lord, in para 135, in conclusion in Nalsa, your lordships gave detailed directions. These, my lord, included directions to recognize transgender persons as a third gender, directions to central and state governments to recognize transgender persons in their self-declared gender identity. And all these directions, my lord, were traceable to the enrichment of Part 3 rights that your lordships recognized. I won't break the convention of this court, my lord, by handing over physical copies of my note. I'll just continue. But the third, my lord, was a very valuable direction to extend Article 16 for protections to transgender persons. So transgender persons were found to be a historically backward class. And this, my lord, perhaps may be the first time that the concept of historical backwardness was expanded to include a new community, what has now been done with EWS, my lords. The next direction to central and state governments was to address health issues of transgender persons. For instance, my lord, directions to NACO to set up sero-surveillance centers, or, my lord, to provide separate toilets. So here the direction, my lord, aside from the declaration of law, the direction, my lord, was traceable to the right to health under Article 21. There was also a direction, my lord, to the central and state governments to address the problems of fear, shame, gender dysphoria, etc. So therefore, my lord, to bring about a change in social values regarding transgender persons. So this is the extent, my lord, of the directions which were given in NALSA, along with the declarations. And finally, my lord, direction to the central and state governments to frame social welfare schemes, which are also traceable to Part 3 rights. Now, what has been the effect of the directions coupled with the declaration that fell from my lords in NALSA? Did Parliament stop debating the issue, or various state legislatures, as has been indicated to my lords? Did social debate on these issues stop? Not at all. What happens, my lord, is we now have many states, including the state of Madhya Pradesh, for example, which have brought about policies for the welfare of transgender persons. And my lord, my friend Mr. Dwivedi appeared on behalf of the state of Madhya Pradesh. But like me, my lord, he is from the great state, may I say, of Uttar Pradesh. And my lord may see what the state of Uttar Pradesh did, following my lord's directions in NALSA. The 7th State Law Commission, my lord, in Uttar Pradesh, entirely relying on my lord's directions in NALSA, finds that they have been directed to improve the conditions of transgender persons and specifically take up the issue, my lord, of laws of inheritance. So what do they say, my lord? The Hindu Succession Act as well as the Indian Succession Act are central legislations, and although the state government has power to amend these legislations with the concurrence of the central government, this has a long procedure. Therefore, this commission has confined its study to the right of succession in agricultural property as well as the grant of lease regarding Abadi lands in Uttar Pradesh. And what, my lord, has the great state of Uttar Pradesh, for which I'm a proud citizen, my lord, of Allahabad, has it held? They amend the Uttar Pradesh Revenue Code in 2020, and what do they introduce? The family in relation to a tenure holder means himself or herself and his wife or her husband or third gender spouse. This is the current state of the law in UP, my lord. As the case may be, other than a judicially separated wife or husband or third gender spouse, minor sons, minor daughters, other than married daughters, and third gender minor issue. So not only, my lords, following your lordship's declaration and directions in NALSA, not only do state legislatures now recognize third gender children as successors to the estate, they also recognize the possibility of third gender marriage, of marriage of third gender persons, as the statute calls it, and in fact, even situations where there may be a judicial separation of such persons. And thereafter, my lord, they are incorporated into the degrees of succession as the RAND revenue codes imagine, my lord. So, my lord, my submission is that your lordships open the door. Your lordships tell us as a country where the law stands and where our constitutional values stand. And then, my lords, a social debate happens, a legislative debate happens. And my lords, we as a country, we adhere to the constitution. We bring ourselves, we rise, my lord, to the level of the constitution. The last submission I'll make is this. Your lordships have in effect been told that because there's a vast problem of statutory interpretation before my lords, your lordships should not touch the constitutional issue. That your lordships will be so troubled by a question of statutory interpretation, however frequently it may arise, my lord, and however many statutes it may arise. But if I may just submit to your lordships, if my lords take yourselves back, perhaps 15 years or maybe even more, when my lord sat as single judges in the high courts. And perhaps, my lord, a young Justice Narasimha then appears before my lords. And my lords, these issues come up, my lords, in MAT FCs, in MAT appeals, in FAOs. And they are questions, my lords, then of statutory interpretation. They arise, my lord, in individual cases relating to individuals who come before my lords in many combinations, as my Lord Justice Bhatt has put to us throughout the course of these proceedings. My lords, look at the facts. And my lords, this is why, my lords, we are not running away from a question of statutory interpretation. We are not saying that these questions are insurmountable. It was asked in this court, my lord, who will be the father or who will be the mother? My lords will look at the statute, as my lords would have done 15, 18 years ago. Look to the statute, look to the law and the declarations laid down by the Honorable Supreme Court, and will find solutions for the persons who come before them. Because, my lord, Parliament can choose when it decides to address an issue. Parliament can choose, there may be a social problem, and Parliament can turn a blind eye. But, my lords, your lordships, the high courts, and the courts below, the family courts, the civil courts, they do not have that luxury, my lords. When persons raise a list before your lordships, when they come with a cause of action, the courts have to address those questions, and they have already been so doing. There are cases going back to the 1990s, my lord, where transgender persons have come raising questions, my lord, do we fall under the HSA, for example? And the courts, in one occasion, say, no, your customary law applies to you. In another case, my lord, again involving transgender persons, the courts say, no, Muslim law applies to you. So, my lords, our only submission is this. Today, what is the reference before your lordships? Your lordships limited the reference to the Special Marriage Act. We are not going beyond that act, whether it is in questions of the Hindu Marriage Act, my lord, or on questions of other statutes. Because that was not the nature of the reference. But it's not, my lord, that these questions are in any way unanswerable. So let me end, my lord, with this. It fell from my Lord Justice Bhatt, for example, that suppose there are two Hindu women who are a couple, and one of them passes intestate. So let's take the case, my lord, of a female Hindu passing intestate. How would my lords then interpret the HSA? And my lord, it's been argued on this side that some have argued that Section 21A ought not to apply. Some have argued, and I have argued, that 21A ought to apply. My note deals with that in detail. I won't trouble your lordship with it anymore. But let's suppose, my lord, that we come to this point that there's a question of whether the Hindu Succession Act applies, my lord, to, my lord, a female Hindu who dies intestate. What does 15 say, my lord? The property of a female Hindu dying intestate devolves according to rules set out in section 16. Firstly, upon sons and daughters, including the children of any predeceased son or daughter. Secondly, upon the heirs of the husband. Thirdly, upon the father and mother. Fourthly, so and so. So what happens here, my lord? And I'll just end with this. My lords will deal with the question of a female Hindu, my lord, who has a spouse, and therefore there will be a question at that stage of does this act now envisage that that the spouse of a female Hindu is covered here, but her husband, but the children, my lord, will be covered. And the issue, my lord, as to how these statutes will be interpreted, what will be the interpretation, my lord, is one to be left to those courts to decide. I'm highly obliged, my lord.
Thank you.
I'm highly obliged.
So we'll conclude here. We'll reserve judgment. Thank you, everyone.
Grateful, Lord. It was
Immensely grateful.
slightly,
Yeah.
Lord.
And what a pleasure it is to see all five of your lordships today sitting here in court. Much obliged.
Grateful, Manoj.
Thank you.
Thank you, everyone.
Thank you.
The weather turned absolutely bad. Unbelievable. What I saw the day previous to when I saw while I landed to what I was now seeing, sudden change. It turned blizzardous. How this particular thing came up was because Kal Bulkuma realized that the map that he was being shown had a straight line drawn from a point called NJ 9842 joining the Karakoram Pass. It's not one man who does it. It's a team that does it. Jal Chibba was quite forthright. He said, look, the Chinese have occupied Aksai Chin because we were not at Aksai Chin then. And since it's our area, we must occupy it. Pakistanis were sponsoring expeditions through the Saltoro ridgeline because between the Saltoro ridgeline and the Karakoram mountains is the Siachen glacier. Ziaul Haq himself telling DG ऐसा है पंजाब में इनको लगाए रख तू and Siachen will take. So Pakistan is not a country which can be trusted at all. Here to sustain 10 men on top of Belafonla probably would have a tail which is of 40 to 50 men. When we were hoisting the national flag over there, just about reaching Belafonla, I find a helicopter coming from the Pakistani direction. He saw that these Indians are already on top of Belafonla. So he took a U-turn and went back.
Namaste, Jai Hind. Welcome to another edition of ANI Podcast with Smita Prakash. Joining me on this edition is my colleague Ajit Dubey, Editor, National Security. 13th April 2023 marks the 39th anniversary of Operation Meghdoot. It was the Indian Army operation to seize control of the Siachen Glacier, which was considered the highest battlefield in the world. In 1984, the Kumaon Regiment, one of the oldest infantry regiments of the Indian Army, and units from the Ladakh Scouts, nicknamed Snow Leopards, were tasked with the responsibility of digging into and controlling the critical peaks and passes of the glacier. Why was this significant? What role did it play in the India-Pakistan conflict? Did we learn lessons from the operation on the LOC, the line of control between India and Pakistan? And has it come into play when our forces deal with the ground situation at the line of actual control with China? To speak on Operation Meghdoot, I have with me Lieutenant General Sanjay Kulkarni, recipient of the Param Vishisht Seva Medal, Ati Vishisht Seva Medal, Shaurya Chakra Sena Medal, Vishisht Seva Medal. Thank you for coming on the podcast, General Kulkarni. It's an absolute honor to have you here. 39 years since Operation Meghdoot. You were a young officer then. So tell us what happened then.
Firstly, thank you very much to have invited me. It couldn't have had I could not have asked for a better platform. Wonderful. Thanks.
3A to provide NCTD with vast executive and co-extensive legislative powers except in the excluded subjects. A combined reading of the majority opinion and the concurring opinions of Justice Chandrachud and Justice Bhushan indicates that the phrase "insofar as any such matter is applicable to union territories" does not restrict the legislative powers of NCTD. While the 2018 Constitution Bench judgment provides sufficient clarity on the interpretation of the phrase "insofar as any such matter is applicable to union territories," we find it necessary to deal with the arguments made by the Union of India that the phrase must be read in a restricted manner. Article 239 AA3A confers legislative power to the NCTD. However, it does not confer legislative power to NCTD over all entries in List 2. Article 239 AA3 provides multiple safeguards to ensure that the interest of the Union of India is preserved. First, subclause A of clause 3 removes 3 entries in List 2 from the legislative domain of NCTD. It provides that NCTD shall not have the power to enact laws on matters with respect to entries 1, 2, and 18 of the state list, and entries 64, 65, and 66 of that list insofar as they relate to the said entries 1, 2, and 18. Second, subclause B of clause 3 clarifies that Parliament has the power to legislate on any matter for a union territory, including on subjects with respect to which NCTD has legislative power under Article 239 AA3A. In other words, Parliament has a plenary power to legislate on a subject in any of the 3 lists of the 7th schedule for NCTD. Third, it provides that where there is a repugnancy between a law enacted by the Legislative Assembly of NCTD and a law enacted by Parliament, the latter will prevail. The law enacted by the Legislative Assembly shall, to the extent of the repugnancy, be void. Unlike Article 254, which provides for the overriding power of Parliament only on subjects in the concurrent list. Parliament has overriding power in relation to the NCTD over subjects in both List 2 and List 3. Fourth, the second proviso to Article 239 AAC provides that Parliament may enact at any time any law with respect to the same matter by including a law adding to, amending, varying, or repealing the law so made by the Legislative Assembly. Fifth, under 239 AA7A, Parliament may by law make provisions for giving effect to or supplementing the provisions in the foregoing clauses of 239 AA, and for all matters incidental and consequential thereto. The article stipulates that such law shall not be deemed to be an amendment of the Constitution for the purposes of Article 368, which deals with the power and procedure to amend the Constitution. Thus, Article 239 AA3 balances between the interests of NCTD and the Union of India. Article 239 AA expressly excludes entries 1, 2, and 18 of List 2 from the ambit of the legislative competence of the Legislative Assembly. 239 AA also stipulates that the legislative power of NCTD is excluded with respect to entries 64, 65, and 66 of List 2, insofar as they relate to entries 1, 2, and 18. Entry 1 deals with public order, entry 2 deals with police, and entry 18 deals with land. When we explain the entries, thus the exclusion of entries 64, 65, and 66 to the extent that it relates to entries 1, 2, and 18 from the legislative competence of NCTD indicates that the governance structure envisaged in Article 239 AA for NCTD was only to exclude specific entries from its legislative competence. To read the phrase insofar as such matter is applicable to the Union territories as introducing an implied exclusion of the legislative powers of NCTD with respect to certain other entries would be contrary to the plain meaning of the provision. Article 239 AA establishes the Legislative Assembly for NCTD. The seats in the Legislative Assembly are filled by a direct election from the constituencies of NCTD. The Legislative Assembly of NCTD embodies the constitutional principle of a representative democracy similar to the Legislative Assembly of the state. The members of the Legislative Assembly of the NCTD are selected by the electorate of Delhi to represent their interests. Article 239 AA must be interpreted to further the principle of representative democracy. To interpret the phrase insofar as any such matter is applicable to Union territories in a restrictive manner would limit the legislative power of the elected members of the Assembly. The members of the Legislative Assembly have been chosen by the electorate to act in their stead. Thus, the legislative competence of NCTD must be interpreted to give full impetus to the will of the electorate. In page 53. The principles of democracy and federalism are essential features of our Constitution and form a part of the basic structure. Federalism in a multicultural, multi-religious, multi-ethnic, and multilinguistic country like India ensures the representation of diverse interests. It is a means to reconcile the desire of commonality along with the desire for autonomy and accommodate diverse needs in a pluralistic society. Recognizing regional aspirations strengthens the unity of the country and embodies the spirit of democracy. Thus, in any federal constitution, at a minimum, there is a dual polity. That is, two sets of government operate, one at the level of the national government and the second at the level of the regional federal units. These dual sets of government, elected by we the people in two separate electoral processes, is a dual manifestation of the public will. The priorities of these two sets of government, which manifest in a federal system, are not just bound to be different, but are intended to be different. While NCTD is not a full-fledged state, its legislative assembly is constitutionally entrusted with the power to legislate upon the subjects in the state and list and concurrent lists. It is not a state under the first schedule to the Constitution, yet it is conferred with power to legislate upon subjects in List 2 and 3 to give effect to the aspirations of the people of NCTD. It has a democratically elected government which is accountable to the people of NCTD. Under the constitutional scheme, NCTD was given legislative power which, though limited in many aspects, is similar to states. In that sense, with the addition of Article 239 AA, the Constitution created a federal model with the Union of India at the center and the NCTD at the regional level. This is the asymmetric federal model adopted for NCTD. While NCTD remains a union territory, the unique constitutional status conferred upon it makes it a federal entity for the purpose of understanding the relationship between the union and the NCTD. A combined reading of Articles 73 and 162 of the Constitution indicates that the Union has exclusive executive power over entries in List 1. The states have exclusive executive power over entries in List 2. With respect to List 3, that is a concurrent list, the Union shall have executive power only if provided by the Constitution or by a law of Parliament. The states shall have executive power over the entries in List 3. However, if a central legislation or a provision of the Constitution confers executive power to the Union with respect to a List 3 subject, then the executive power of the state shall be subject to such law or provision. The executive power of the Union in a state over matters on which both states and the Union of India can legislate, that is the concurrent list, is limited to ensure that the governance of the states is not taken over by the Union. This would completely abrogate the federal system of governance and the principle of representative democracy. It is with this objective in mind that the members of the Constituent Assembly thought it fit to limit the executive power of the Union in a state over matters on which the state legislature also has legislative competence. The principle in Articles 73 and 162 would equally apply to the scope of executive power over matters which are within the legislative competence of both the Union and the GNCTD. This is because the objective of the provisions is to limit the executive power of the Union in the territorial limits where there is an elected government of a federal unit. Both Parliament and the legislature of NCTD have legislative competence over List 2 and List 3. For the purposes of NCTD, both List 2 and List 3 are concurrent lists. Thus, the delimitation of executive power between Parliament and the government of NCTD with respect to entries in List 2 and List 3 are guided by these principles. Both Parliament and the legislature of the NCTD have the power to enact laws with respect to List 2, subject to the caveat that entries 1, 2, and 18, and entries 64, 65, and 66, inasmuch as they relate to entries 1, 2, and 18, are carved out of the domain of the Legislative Assembly of GNCTD and List 3. The executive power of NCTD shall extend to all entries in List 2 and List 3, other than those entries which are expressly excluded in Article 239 AA3. Such power shall be subject to the executive power of the Union through the Lieutenant Governor only when the Union has been granted such power by the Constitution or a law of Parliament. Therefore, the executive power of NCTD in the absence of a law by Parliament shall extend to all subjects on which it has power to legislate. It was held when we cover Rule 46 of the rules, and we say, the rule provides that the Lieutenant Governor shall exercise such powers and functions with respect to persons serving in the administration of NCTD as may be entrusted to him under the provisions of the rules and orders regulating the conditions of service of such persons or by any other order of the President. The term administration in this rule must be considered in the context of Article 239 AA3 and Section 41 of the GNCTD Act. The executive administration by the Lieutenant Governor, in his discretion, can only extend to matters which fall outside the purview of the powers conferred on the Legislative Assembly, but it extends to powers or functions entrusted or delegated to him by the President, or in which he is required by or under law to act in his discretion or to exercise any judicial or quasi-judicial functions. The term administration cannot be understood as the entire administration of GNCTD. Otherwise, the purpose of giving powers to a constitutionally recognized and democratically elected government would be diluted. In a democratic form of government, the real power of administration must reside in the elected arm of the state, subject to the confines of the Constitution. A constitutionally entrenched and democratically elected government needs to have control over its administration. The administration comprises of several public officers who are posted in the services of a particular government, irrespective of whether or not that government was involved in their recruitment. For instance, an officer recruited by a particular government may serve on deputation with another government. If a democratically elected government is not provided with the power to control the officers posted within its domain, then the principle underlying the triple chain of collective responsibility would become redundant. That is to say, if the government is not able to control and hold to account the officers posted in its service, then its responsibility towards the legislature as well as the public is diluted. The principle of collective responsibility extends to the responsibility of officers, who in turn report to the ministers. If the officers stop reporting to the ministers or do not abide by their directions, the entire principle of collective responsibilities is affected. A democratically elected government can perform only when there is an awareness on the part of officers of the consequences which may ensue if they do not perform. If the officers feel that they are insulated from the control of the elected government which they are serving, then they become unaccountable or may not show commitment towards their performance. We have already held that the relationship between the Union and the NCTD resembles an asymmetric federal model, where the latter exercises its legislative and executive control in specified areas of the state list and concurrent list. Article 239AA, which conferred a special status to NCTD and constitutionally entrenched a representative form of government, was incorporated in the Constitution in the spirit of federalism, with the aim that the residents of the capital city must have a voice in how they are to be governed. It is the responsibility of the government of the NCTD to give expression to the will of the people of Delhi who elected it. Therefore, the ideal conclusion would be that GNCTD ought to have control over services subject to exclusion of subjects which are out of its legislative domain. If services are excluded from its legislative and executive domain, the ministers and executives and the executive who are charged with formulating policies in the territory of NCTD would be excluded from controlling the civil service officers who implement such executive decisions. The legislative and executive power of NCTD over entry 41 shall not extend over to services related to public order, police, and land. However, legislative and executive power over services such as Indian administrative services or joint cadre services, which are relevant for the implementation of policies and the vision of NCTD in terms of day-to-day administration of the region, shall lie with the NCTD. Officers thereunder may be serving in NCTD even if they were not recruited by the NCTD. In such a scenario, it would be relevant to refer as an example to some of the rules which clearly demarcate the control of all India or joint cadre services between the union and the states. NCTD, similar to other states, also represents the representative form of government. The involvement of the Union of India in the administration of NCTD is limited by constitutional provisions, and any further expansion would be contrary to the constitutional scheme of governance. We reiterate that in light of Article 239AA and the 2018 Constitution Bench judgment, the Lieutenant Governor is bound by the aid and advice of the Council of Ministers of NCTD in relation to matters within the legislative scope of NCTD. As we have held that NCTD has legislative power over services, excluding public order, police, and land, under entry 41 in list 2, the Lieutenant Governor shall be bound by the decisions of GNCTD on services as explained above. To clarify, any reference to Lieutenant Governor or over services, excluding services relating to public order, police, and land, in relevant rules, shall mean Lieutenant Governor acting on behalf of NCTD. Now, the conclusion. The division of administrative powers between the Union and the NCTD, as explained in this section, must be respected. In view of the discussion above, the following are our conclusions. A. There does not exist a homogeneous class of union territories with similar governance structures. B. NCTD is not similar to other union territories. By virtue of Article 239AA, NCTD is accorded a sui generis status, setting it apart from other union territories. C. The Legislative Assembly of NCTD has competence over entries in List 2 and List 3, except for the expressly excluded entries of List 2. In addition to the entries in List 1, Parliament has legislative competence over all matters in List 2 and List 3 in relation to NCTD, including the entries which have been kept out of the legislative domain of NCTD by virtue of Article 239AA 3A D. The executive power of NCTD is coextensive with its legislative power, that is, it shall extend to all matters with respect to which it has the power to legislate. E. The Union of India has executive power only over the three entries in List 2, over which NCTD does not have legislative competence. F. The executive power of NCTD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by a law enacted by Parliament. G. The phrase insofar as any such matter is applicable to Union territories in Article 239 AA3 cannot be read to further exclude the legislative power of NCDD over entries in the state list or concurrent list over and above those subjects which have been expressly excluded. H, with reference to the phrase subject to the provisions of this Constitution in Article 239 AA3, the legislative power of NCTD is to be guided and not just limited by the broader principles and provisions of the Constitution. And I, NCTD, has legislative and executive power over services, that is entry 41 of list 2 of the 7th schedule, because 1, the definition of state under section 358 of the General Clauses Act 1897 applies to the term state in part 14 of the Constitution. Thus, part 14 is applicable to union territories. And 2, the exercise of rule-making power under the proviso to Article 309 does not oust the legislative power of the appropriate authority to make laws over entry 41 of the state list. We have answered the issue referred to this Constitution bench by the order dated 6 May 2022. The registry shall place the papers of this appeal before the regular bench for disposal after obtaining the directions of the Chief Justice on the administrative side.
Lord, immensely grateful to your Lordship.
The petitioners have urged that the order of this court dated 27 June 2022 relied on the decision in Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions. This submission cannot be accepted. Although the parties may have addressed this court on the applicability of Nabam Rebia, the order dated 27 June 2022 did not rely on Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions on the ground that a notice of intention to move a resolution for his removal had been issued. This court instead granted an extension of time to the persons against whom disqualification petitions were filed to file their written submissions in view of the principles of natural justice. Based on the submissions which have been canvassed before us, we are of the view that the decision in Nabam Rebia merits reference to a larger bench because a substantial question of law remains to be settled. The following are our prima facie reasons for reaching this conclusion. I'll not read out all the reasons for the reference to a larger bench of Nabam Rebia, save and except to note one thing. It appears that the following aspects were not considered in Nabam Rebia. 1, whether the temporary disablement of the functions of the Speaker under the 10th schedule is prone to misuse by MLAs who anticipate that disqualification petitions will be instituted against them or by MLAs against whom disqualification petitions have already been instituted. And 2, whether a constitutional hiatus in the operation of the 10th schedule ensues because of the temporary disablement of the Speaker. To give quietus to the issue, we refer the following question and any allied issues which may arise to a larger bench, whether the issuance of a notice of intention to move a resolution for the removal of the Speaker restrains them from adjudicating disqualification petitions under the 10th schedule of the Constitution. Then we have said that pending the decision of the larger bench, as an interim measure, adoption of the following procedure may subserve the objective of the 10th schedule, the symbols order, as well as Article 179C. It may also provide some amount of clarity and certainty. And the points which we have then made for the interim is that the investing of exclusive adjudicatory jurisdiction upon the Speaker to determine the complaints under the 10th schedule will entitle the Speaker to rule upon and decide applications questioning their jurisdiction. B. 1. The Speaker is entitled to rule on applications which require them to refrain from adjudicating proceedings under the 10th schedule on the ground of initiation of a motion for the removal under Article 179C. A Speaker can examine if the application is bona fide or intended only to evade adjudication. 2. If the Speaker believes that the motion is well-founded, they may adjourn the proceedings under the 10th schedule till their decision of their removal is concluded. On the other hand, if they believe, page 61 ko correction hai, if they believe that the motion is not as per the procedure contemplated under the Constitution, read with the relevant rules, they are entitled to reject the plea and proceed with the hearing. And 3, the decision of the Speaker either to adjourn the proceedings under the 10th schedule in view of the pending proceedings under Article 179C or to proceed with the hearing will be subject to judicial review. As the decision of the Speaker relates to their jurisdiction, the bar of a quae time action as contemplated in Quixote Holohan will not apply. Now, having referred the matter to a larger bench, we have given our reasons for coming to the conclusion that we are still dealing with the matter on merits because Nabam Rebia, strictly speaking, did not arise in the matter before us, but we thought Nabam, the controversy, should be settled by a reference to 7 judges. So I'll now go to the what we have said on the merits of this particular case. The House of the People and the legislative assemblies of states are constituted of members directly elected by the electorate. The candidate who secures the highest number of votes is returned to the assembly. The political party which reaches the halfway mark forms government. A coalition of political parties may form the government if no single political party reaches the halfway mark. Articles 75 and 164 provide that the Council of Ministers is collectively responsible to the House of People and the Legislative Assembly of the state, respectively. The legislators who are directly elected by the people have a duty to hold the executive accountable on the floor of the House. Legislative procedures serve 2 objectives. First, they enable deliberation and discussion on the floor of the House to hold the executive accountable, and such deliberation also produces better constitutional outcomes. And second, they create a system to place a check on the exercise of power by the incumbent government. Certain procedural requirements prescribed by the Constitution safeguard constitutional values. This is reflected in Article 368, which prescribes a special majority to amend certain constitutional provisions, which, according to the members of the Constituent Assembly, hold a higher constitutional and democratic value. Certain other legislative procedures further democratic processes and accountability and prevent the concentration of power in the hands of the incumbent government. Article 212 cannot be interpreted as placing all procedural infringements beyond the pale of judicial review. Such an interpretation would completely disregard the importance of legislative processes in a constitutional democracy. Now, we have dealt with the whip as to whether the whip is really a whip appointed by the legislature party or by the political party. And we say to hold that it is the legislature party which appoints the whip would be to sever the figurative umbilical cord which connects a member of the House to the political party. It would mean that legislators can rely on the political party for the purpose of setting them up for election, that their campaign would be based on the strengths and weaknesses of the political party and its promises and policies, that they could appeal to the voters on the basis of their affiliation with the party, but that they can later disconnect themselves entirely from that very party and be able to function as a group of MLAs which no longer owes even a hint of allegiance to the political party. This is not the system of governance that is envisaged by the Constitution. In fact, the 10th schedule guards against precisely this outcome. That a whip be appointed by the political party is crucial for the sustenance of the 10th schedule. The entire structure of the 10th schedule, which is built on political parties, would crumble if this requirement is not complied with. It would render the provisions of the 10th schedule odious and have wider ramifications for the democratic fabric of this country. Thus, the courts cannot be excluded by Article 212 from inquiring into the validity of the action of the Speaker in recognizing the whip. On 25 November 2019, a meeting with the newly elected MLAs belonging to the Shiv Sena was chaired by Mr. Uddhav Thackeray in his capacity as the Shiv Sena president, party president, Paksh Pramukh. The resolution notes that the MLAs unanimously resolved that all decisions in the meeting would be taken by Mr. Thackeray. A resolution was issued appointing Mr. Eknath Shinde as the group leader of the SSLP and Mr. Sunil Prabhu as the chief whip. On 21 June 2022, some members of the SSLP held a meeting under the chairmanship of the president of the Shiv Sena, Mr. Uddhav Thackeray. In the meeting, it was resolved to remove Mr. Shinde as the group leader of the SSLP and appoint Mr. Ajay Chaudhary. The resolution was signed by Mr. Uddhav Thackeray in his capacity as the president of the party on the official letterhead of the office of the SSLP. Then, having dealt with that, we say the Speaker was aware of the emergence of two factions in the Legislative Party on 3 July 2022 when he appointed a new whip and a new leader, because the resolution of the respondents specifically mentions that a split had occurred due to prevailing dissatisfaction in some MLAs of the Shiv Sena. Further, the fact that there were two resolutions appointing two different whips and two different leaders would no doubt have resulted in the Speaker inferring that there were two factions of the Shiv Sena. The Speaker, on taking cognizance of the resolution passed by the faction of the SSLP, led by Mr. Shinde, did not attempt to identify which of the two persons who were nominated, namely Mr. Prabhu or Mr. Gogaole, were authorized by the political party. In a contentious situation such as this, the Speaker should have conducted an independent inquiry based on the rules and regulations of the political party to identify the whip authorized by the Shiv Sena political party. For the reasons detailed in the preceding paragraphs, the Speaker must only recognize the whip appointed by the political party. The decision of the Speaker recognizing Mr. Gogaole as the chief whip of the Shiv Sena is illegal because the recognition was based on the resolution of a faction of the Shiv Sena legislature party without undertaking an exercise to determine if it was the decision of the political party. Harmonizing the 10th schedule with paragraph 15 of the symbols order. This court cannot accept the solution proposed by the petitioners and lay down a constitutional sequence. To hold that the Election Commission of India is barred from adjudicating petitions under paragraph 15 of the symbols order until the final adjudication of the disqualification petitions under the 10th schedule would be in effect to indefinitely stay the proceedings before the Election Commission of India. This is because an order of the Speaker attains finality only after all avenues for appeal have been exhausted or are barred by the passage of time. The time that it would take for an order of the Speaker to attain finality is uncertain. The Election Commission of India is a constitutionally entrenched institution which is entrusted with the function of superintendence of and control over the electoral process. The ECI, which is a constitutional authority, cannot be prevented from performing its constitutional duties for an indefinite period of time. Proceedings before one constitutional authority cannot be halted in anticipation of the decision of another constitutional authority. In arriving at this decision, it is not necessary for the ECI to rely on the test of majority in the legislature alone. In cases such as the present one, it would be futile to assess which group enjoys a majority in the legislature. Rather, the Election Commission of India must look to other tests, in order to reach a conclusion under paragraph 15 of the symbols order. The other tests may include an evaluation of the majority in the organizational wings of the political party, an analysis of the provisions of the party constitution, or any other appropriate test. Then we deal with the judgment in Sadiq Ali's case. And having dealt with the judgment, we say the disqualification proceedings before the Speaker cannot be stayed in anticipation of the decision of the ECI. In cases where a petition under paragraph 15 of the symbols order is filed after the alleged commission of prohibitory conduct, the decision of the ECI cannot be relied upon by the Speaker for adjudicating disqualification proceedings. If the disqualification petitions are adjudicated based on the decision of the ECI in such cases, the decision of the ECI would have a retrospective effect. This would be contrary to law. The question before this court is, what is the impact of the deletion of paragraph 3 of the 10th schedule? This question has arisen in the context of both the factions of the Shiv Sena claiming to be the real Shiv Sena. In effect, this points to the existence of a split within the SSLP. However, no faction or group can argue that they constitute the original political party as a defense against disqualification on the ground of defection. The inevitable consequence of the deletion of paragraph 3 of the 10th schedule is that the defense of a split is no longer available to members who face disqualification proceedings. In cases where a split has occurred in a political party or in a legislative party, members of neither faction may validly raise the defense that they are the political party in the event that each faction files petitions for the disqualification of members of the other faction. The defense sought to be availed of must be found within the 10th schedule as it currently stands. The deletion of paragraph 3 impacts the proceedings under paragraph 2(1)(b) as well. When there are two whips appointed by two or more factions of the political party, the Speaker, as held in the preceding section of the judgment, decides which of the two whips represents the political party. Thus, the adjudication of the Speaker on whether a member must be disqualified under paragraph 2(1)(b) would also depend on the decision of the Speaker recognizing one of the two or more whips. We accordingly answer the question referred to us as noted in paragraph 32F of the judgment. To avert a no confidence motion, the incumbent government may not advise the governor to convene a session of the assembly, and the Speaker may adjourn the sitting of the House to prevent voting for granting leave to move a motion of no confidence. If the Speaker and the government attempt to circumvent a no confidence motion, the governor would be justified in exercising the power under Article 174 without the aid and advice of the Council of Ministers. Now we have dealt with the role of the governor in the present case. The petitioners have urged that the governor was not justified in reaching the conclusion that he did on the basis of the resolution dated 21 June 2022 because, 1, the 34 MLAs belonging to the Shiv Sena did not express their intention to exit the Maha Vikas Aghadi government, and 2, the MLAs who signed the resolution constituted a faction of the SSLP. Although the resolution dated 21 June 2022 specifies that some MLAs of the SSLP were dissatisfied with the functioning of the MVA government, it does not record their intention to withdraw support from the government. Among the 34 MLAs who signed the resolution dated 28 June 2022, a few were also ministers in the government. On the basis of this resolution, the governor concluded that a majority of the Shiv Sena MLAs have given a clear indication that they intend to exit from the Maha Vikas Aghadi government. The assembly was not in session when Mr. Fadnavis and 7 independent MLAs wrote to the governor. However, there was no attempt made by the members of the opposition parties to issue a notice for a no confidence motion against the incumbent government. The governor had no objective material on the basis of which he could doubt the confidence of the incumbent government. The resolution on which the governor relied did not contain any indication that the MLAs wished to exit from the MVA government. The communication expressing discontent on the part of some MLAs is not sufficient for the governor to call for a floor test. The governor ought to apply his mind to the communication or any other material before him to assess whether the government seemed to have lost the confidence of the House. We use the term opinion to mean satisfaction based on objective criteria as to whether he possessed relevant material and not to mean the subjective satisfaction of the governor. Once a government is democratically elected in accordance with law, there is a presumption that it enjoys the confidence of the House. There must exist some objective material to dislodge this presumption. The MLAs did not express their desire to withdraw support from the MVA government in the resolution dated 21 June 2022. Even if it is assumed that the MLAs implied that they intended to exit from the government, they only constituted a faction of the SSLP and were at most indicating their dissatisfaction with the course of action adopted by their political party. The political imbroglio in Maharashtra arose as a result of party differences within the Shiv Sena. However, the floor test cannot be used as a medium to resolve internal party disputes or intra-party disputes. Dissent and disagreement within a political party must be resolved in accordance with the remedies prescribed under the party constitution or through any other methods that the party choose to opt for. There is a marked difference between a party not supporting a government and individuals within a party expressing their discontent with the party leadership and functioning. The governor is the titular head of the state government. It's a constitutional functionary who derives his authority from the constitution. This being the case, the governor must be cognizant of the constitutional bounds of the power vested in him. He cannot exercise a power that is not conferred on him by the constitution or a law made under it. Neither the constitution nor the laws enacted by parliament provide for a mechanism by which disputes amongst members of a political party, particularly, can be settled. They certainly do not empower the governor to enter the political arena and play a role, however minute, either in inter-party disputes or in intra-party disputes. It follows from this that the governor cannot act upon an inference that he has drawn that a section of the Shiv Sena wished to withdraw their support to the government on the floor of the House. It is true that the letter dated 25 June 2022 sent by some MLAs of the Shiv Sena to the governor requesting him to issue directions to the appropriate authorities for the restoration of their security details mentions that those MLAs no longer wanted to be a part of the corrupt MVA government. However, this cannot be taken to mean that they had withdrawn their support on the floor of the House. Nothing in any of the communications relied upon by the governor indicates that the dissatisfied MLAs from the Shiv Sena intended to withdraw their support to the Chief Minister and the Council of Ministers. At the highest, the various communications expressed the fact that a faction of the MLAs disagreed with some policy decisions of the party. The course of action they wished to adopt in order to air their grievances and redress them was, at the time the floor test was directed to be conducted, uncertain. Whether they would choose to enter deliberations with their colleagues in the House or in the political party, or mobilize the cadres, or resign from the assembly in protest, or opt to merge with another party was uncertain. Therefore, the governor erred in relying upon the resolution signed by a faction of the SSLP MLAs to conclude that Mr. Thackeray had lost the support of the majority of the House. Second, the governor relied on the letter dated 25 June 2022 from 38 SSLP members, claiming that the security provided to them and to their families was illegally withdrawn. The MLAs claimed that the security was withdrawn to coerce them into continuing to support the MVA government against their free will. Therefore, they demanded the restoration of the security provided to them and to their family members. After receiving the letter, the governor issued directions to the state police to provide adequate protection to the MLAs, the members of their families, and their property. However, the lack of security to the MLAs has no bearing on the question of whether the government enjoys the confidence of the House. The appropriate response of the governor in such cases is to ensure that security that they were lawfully entitled to continues to be provided to them if it has been removed. This was an extraneous reason that was considered by the governor. The third communication that the governor relied on is the letter dated 21 June 2022 addressed by Mr. Eknath Shinde to the Deputy Speaker, stating that the appointment of Mr. Ajay Chaudhary was illegal. The governor may not inquire into or express an opinion on the validity of proceedings of the legislature. That is exclusively within the domain of the legislature itself, or in certain circumstances, discussed in the previous segment of this judgment, within the domain of courts. The discretionary power of the governor under Article 163 of the Constitution is limited to situations where a constitutional provision expressly provides it, or where the Constitution cannot be construed otherwise than to grant such discretion. Hence, the governor ought not to have relied on the letter dated 21 June 2022. In any event, the contents of the letter did not indicate anything to suggest that the then Chief Minister, Mr. Thackeray, had lost the confidence of the House. Finally, the governor relied on the letters written by Mr. Fadnavis and 7 independent MLAs, calling upon him to direct Mr. Thackeray to prove his majority on the floor of the House. First, both Mr. Fadnavis as well as the 7 MLAs could have well moved a motion of no confidence. Nothing prevented them from doing so. Second, a request by some MLAs for a direction to the Chief Minister to prove his majority does not, taken alone, amount to a relevant and germane reason to call for a floor test. There must be some objective material in addition to a mere request to call for a floor test. In the present case, the governor did not have any objective material before him to indicate that the incumbent government had lost the confidence of the House and that he should call for a floor test. And the exercise of discretion by the governor in this case was not in accordance with